Is it part one stand part?
Mr. Chairman.
Sorry, the Honourable Phil Goff.
Mr. Chairman, I want to begin by congratulating the Minister and the Chair, because I think this is a good piece of legislation, and we intend to facilitate this legislation and this part through the House, because by so doing, and the technical amendments that it's making and the improvements and the picking up on one or two things that were wrong with the original bill, we will bring into effect the criminal procedure legislation, the Act, in July of this year, and that Act will be of considerable assistance to New Zealand. It's designed to reduce excessive cost, excessive delay, excessive complexity. It will bring in a modern and fit-for-purpose framework for criminal procedures. And all of those things are important, and I'm particularly keen on the legislation going through because its origins came in at the time that I was Minister of Legislation and then my successors, when we set up the Law Commission to work with the Ministry of Justice. And I want to commend officials in both groups because they worked incredibly hard, and I think by and large they got it right. And where they didn't, well, where the government didn't get it right, the government actually listened and made changes that enabled this legislation and this part of the bill to really attract consensus support. And I just want to quote what the Law Society said about that it argued that cross-party agreement was needed on criminal justice instead of politicising issues that require coherent policy. And I think in this part of the bill, we have got coherent policy, but the tradition of the committee stage is that we ask questions to the Minister, and I wouldn't want the Minister to feel that he just simply had to sit there and rubber stamp everything that happened. So I have a number of questions to the Minister, and the first question is, Minister, was it helpful that the groundwork for this bill was properly laid by proper process, by thorough analysis, by careful consultation, long before the original and primary piece of legislation brought in? The homework was done. I think by and large people got it right, and this wasn't a politicised piece of legislation simply designed to appeal to win some populist supports, even though cynically the Minister or the government knew that that wasn't going to make any change. So the first question was, how important was it, Minister, that the groundwork was laid, the research was done, the analysis was clear, and the consultation was had? And I think, Minister, you'll understand why I'm asking that question, because I can't help but contrast the way this piece of legislation and its primary legislation has been done with the legislation rammed through by the narrowest of margins under urgency in the dead of the night last night. So I'm asking you, I guess, Minister, are there lessons to be learnt from this legislation that you would want to see your colleagues apply to the legislation that went through last night on the Government Communications Security Bureau and the Telecommunications Security Act? I would like to, the second question I'd like to ask to the Minister, and I'll just pause because the Minister's occupied at the moment. I do want him to answer these questions because they are important questions. Minister, what consultation was done with key groups affected by this legislation before it was brought into the House? I assume, Minister, that this was not legislation done in ignorance of the views and the expertise and the attitudes of those who were intimately going to be affected by it. I presume that that consultation with groups like the New Zealand Law Society and Criminal Bar Association, the judges and so on, was done very thoroughly, so that when you introduced this legislation, you knew the realities on the ground. Well, the chairman probably knew too, because he's a very well-informed chairman, but I'm referring to the Minister in this case, Mr. Chairman. The Minister knew that if legislation is to be good legislation, then talk to the people who are most intimately affected by it and involved in it. So I imagine that all of those consultations took place. And of course, if you did that, and if the Minister did that in this bill, can the Minister explain why his colleagues failed to do it in the legislation last night affecting telecommunications companies when they were not consulted, and we don't know, Mr Chairman,
The Honourable Phil Goff.
we don't know even whether that legislation will work. And I ask this question, drawing on the Minister's experience on this bill, because he is also Minister of Corrections, I think. No, he's not, but he should be. He should be. Who is the Minister of Corrections? Anne Tolley. Oh, I thought she was still Minister of Education. Judging from the utter chaos that's going on in the education area, I thought she was still Minister there. But I asked the Minister if he is also aware of the Corrections Amendment Bill, which also affected telecommunications companies, where consultation wasn't done, and the government had to do a total U-turn. So what I'm really asking the Minister is whether he will use his knowledge and his reasonableness to talk to his colleagues to say, learn from this legislation, and for heaven's sake, if we want to build coherent policy and consensus support for it, and we want something that's worked, you've got to do it the right way. Because I fear, Minister, that everything that you have done in this bill and all of the lessons that you've learned in this bill haven't been taken on board at all by your colleagues, including your leader.
None whatsoever.
Because if they were listening to this debate now and they were seeing that the opposition was working cooperatively and constructively with the government, they would say that's a good model in a democracy. That's how democracy should work. So my next question was there a full and proper select committee process? Or did the Minister decide to truncate it, to try to ram the legislation through and to make it as difficult as possible for experts and for members of the public to have their say on legislation, which is a critical part of the democratic process? Because I, from recollection, Minister, recall that there was a full period for submissions, that people were listened to with respect, that the timing was designed to ensure the best possible outcome from the legislation. And I commend you, Minister, for doing that. But I have to ask again why it is that legislation that is critically intrusive in the privacy of New Zealanders and open things up for the abuse of power did not allow for that normal process of consultation last night when we moved the motion on the Government Communications Security Bureau. So what I'm asking the Minister is really whether he will use his experience and his expertise and his proven ability to win the support of all of the groups that will be affected by it and all of the parties in this House to persuade his colleagues that they got it so hopelessly and dramatically wrong last night. So my question to the Minister is, will he pass on what his experience has been? Will he tell the House now that the process that he has followed has worked for good legislation, has worked for the interests of the country, and that this should be the model for all legislation that the government brings through, but in particular highly controversial legislation where enormous powers are given to largely unaccountable agencies which can have huge implications for the privacy of New Zealanders and, in the ultimate, the establishment of a state that has powers over its citizens that contradict democratic processes and principles. So, again to the Minister, congratulations on this specific piece of legislation. Listening to what the Law Society said about the need not to have Henry VIII powers, so that you should not have the executive moving by regulations things that are substantive parts of the legislation. And the Minister in this case listened to the Law Society and he made those changes. So not only in the primary legislation, but also in this largely technical legislation, we have seen exhibited time and again the benefits in a democratic society of getting legislation right, of being fully consultative to groups and to political parties, to listening to submissions, because officials are, they're human, they don't get everything right all the time, so that we have got improvements, even in this technical piece of legislation, that will make the passage of this legislation easy, but most importantly, will make the outcome for New Zealand a good outcome in having legislation that won't be back before the House, won't be repealed by the new government that will come in 2014. I congratulate you, Minister, but I would really like to hear the answers to those questions.
I call the honourable member Chris Farfoe.